In my introduction, I mentioned, and I have mentioned a few times since then, this term balance of probability. And I said at the time I'll explain it in more detail. Well, now's the time, all right? So let's have a look at what this actually is, and there'll be some further explanation. Well, it's the standard of proof used in employment law, in hearings, arbitrations, by chairpersons, arbitrators, and judges when deciding which version of facts of an incident to accept. Okay, so let's explain that standard of proof. Standard of proof means to what degree, what level of evidence do you need to bring. At the weakest level, somebody makes a statement. I saw Mr. So-and-so was drunk. All right. Now, do you then say, okay, Mr. So-and-so was drunk as a matter of fact? Or what do you do? Well, I suggest that that statement is not enough. You'd have to build to that statement. So you'd say, why do you say he was drunk? Well, because his breath smelt of alcohol. His eyes were shut. He was slurring. Now you're getting more information. Okay, so that to the level that you now start to say, as an independent person who wasn't there when that guy was drunk, who's just listening to the story, to the version, the independent person was saying, okay, it sounds to me like the guy actually was drunk. All right, so that's the balance of probability. So there's got to be a level. And then we say probability, we're saying there's degrees of probability. You could say certain, okay? Well, that's like 95% certain. So that's a very high standard. Or you could say probably, I'm not quite sure how you go down from that, but probability means, in very simple terms, and I'm almost scared to put it like this, but it means more than 50%. It's more than 50% likely, probable, that the person was drunk. That kind. All right. So that's what we use as the level, looking at the versions of facts, because you now have a version saying yes, he was drunk, and a version saying no, he wasn't drunk, and you then have to work out. Now, it's not just for chairpersons or arbitrators or whatever. You as a practitioner, you as somebody who is representing the employee or presenting a case or involved in the investigation, you need to understand what this is so that you don't launch into a hearing or inquiry or a forensic investigation or something other when there's just basically a rumor, somebody says. All right? So, very important to actually understand this idea. And one way to explain what a balance of probability is not, and I'm raising these because I've found over the years, lecturing to students and explaining to people at the CCMA and arbitrations and so on, it's not the side with the most witnesses. So a balance of probability is not affected by how many witnesses one side brings. And that's contrary to a lot of understanding that people say, well, I can bring the whole class of students who saw whatever, and then that doesn't matter how many people, because it's not a popularity. It's not it's also not those who shout loudest, that kind of thing. All right, it's also not showing favor to one version because of the party's status. So what I mean by that is sometimes there is a tendency, and there's pressure on, for example, chairpersons to show favor to the employer party. Maybe the chairperson is actually a manager, and he knows if I don't rule in favor of the company, then there could be consequences for me. So there is a bias that is implicit there because of showing favor for a whole range of reasons. So it's not that. You You're looking at it as what I said just now, as an independent person. Okay? And then it's not looking at one party's version over another's, because there's things like women don't lie, managers wouldn't lie, etc. There's a whole lot of those kind of, I don't know, blatant hypocrisies, really, that are out there. And so that has no role in the notion of a balance of probability. What it does mean is deciding which version is probable and then considering which version is the more probable. Do you understand that? So let's unpack that a little bit. So if one version is just not probable, all right, the version is saying, no, aliens came and they go like, oh, no, then it's pretty much, you go like, well, that's just simply not probable. So you can set that aside. But the other side, say the employer's version, has still to be probable. Do you understand? So then we go to the next situation where you have one party, one's version, that is probable, all right, could have happened like that, and the other parties, which is probable, could have happened like that. And then you have to say, well, now, which is the more probable? And that's how you assess these things. Again, I'm not just talking to chairpersons, but I'm talking also in real life. If you want to get somewhere towards the truth, you have to work out which side is more probable, and then set aside your bias, like that kind of person would never have said that. He goes to church, he would never lie, or whatever. All those biases that kick in, that you need to set aside. So that's how, practically speaking. Now I know I'm kind of putting this without a context, without looking at a particular case. But it's important that you have a picture, you have an idea, a concept of what we're talking about. So, practically speaking, how is it decided? Well, a chairperson or arbitrator. So now this is how if you're in that role, this is what you would do. You'd hear all the statements and all the evidence. And then you take the elements. That's why the elements are important. Elements help you to do this as well, of the issue in dispute, and you consider each party's evidence on that element separately, asking whose version is probable. I'm going to give you an example just now to make this hopefully even more comprehensible. Okay, so here you hear everything. So the idea then is that you hear the evidence, or what I found as an arbitrator is you're hearing evidence, and the whole time you're assessing. You're listening to somebody and saying, the witness, are they credible? Is the evidence relevant? All right. Is it admissible? And you listen, you just kind of have that in your mind as you're listening to the person giving their evidence. Right. And then what you do, if you now say this is probable, the chairperson then asks which version is more probable on each element. So you separate it out, and you'll see now. I'm going to give you an example where you literally put the company's version here on that element, and the employee's version there, and then you go like, which side is the more probable? Tick, okay, and then you go down to the next one, tick, and sometimes you would cross over because that's sometimes how these things work. All right, so okay, I'm missing myself here. Okay, so here's an example. Let's take the allegation of insubordination. And now this is not in your workbook, but I want you to see practically how this works. Now we've looked at insubordination. We know what the elements are. So let's take each element, and this is how you would assess, and also how you would present your case. So this is how important it is. So we know the first element is, did the employee, so we take an example, did Mr. Employee, all right? And the employee version is that it's not in dispute. Did he fail or refuse to obey? And the employee's version is, yes, he did refuse to obey. Okay, we're getting into insubordination. There was an instruction. There's no dispute. The instruction was given to him. The other element is the instruction was lawful and reasonable, and then the evidence there, or the version, is the instruction was unlawful. Okay, so you see how this works, is that you're looking at each and you're saying, well, what is actually in dispute here? And the whole arbitration goes to the question of, was the instruction lawful and reasonable? And the version is it was unlawful. Now you take that evidence and you then say, okay, what is the employer's version, that it was lawful and reasonable, the instruction, and the employee's version that it was unlawful? And you unpack those and then come to a conclusion about which was whose version is more probable. So in this example, if you find the instruction was unlawful, then you would say on a balance of probabilities, Mr. Gavani is not guilty of insubordination. Okay, now I know I'm putting this in kind of in the air out there, but if you get a handle on what I'm talking about, you'll find this is a very practical way to deal with these things. Not only to prepare your case, whether you're for the employee or for the company, but if you're a chairperson or an arbitrator, you'll find this very, very useful.